Good morning and welcome to another episode of Law and Order, the program where we discuss legal matters. And today we are going to discuss lending and borrowing money on a personal level. And to do so, we have with us Krishant Fernandopulle, attorney at law. Thank you so much for being with us this morning.
Thank you, Prashant. Thank you for having me here this morning.
All right. Now, to start off, let's talk about some of the issues that people are facing when it comes to this activity of borrowing and lending money on a personal level.
Well, Prashant, the first and foremost, you have to think about the fact that people are facing hardships these days, and people would have to rely on other people and institutions. So certain people would rely on institutions, whereas certain people, like let's say people who are close to you, like your friends, your relatives, your family members, or let's say a colleague even, might come up to you and state that they are facing some hardships, or whether they want to borrow money on a different matter for their business or for an investment purpose. So they might come up to you, and then they would want to negotiate the terms as to how to borrow the money and how to make the payment structure and the prepayment scheme and the repayment procedure, whether it's going to be paid in 1 month, 2 months, or 3 months, or even a year. So you have to consider all these factors before going into an agreement. And the Sri Lankan law envisages the fact that even oral agreements, without agreements where you and I just come to an understanding, where it's just my word which I am giving to you, which will be considered as an agreement. Now, technically, that is an agreement which you can enforce. But however, when you go before courts, it will be always your word against mine. And in a court of law, you have to establish the fact that the money was lent and these agreements were laid out and the terms were laid out, and for that you need evidence. So the best way to do it, Prashant, is always to go for an agreement, written agreement. So we'll be discussing in this program as to what sort of agreements you can enter into, and then the process of how to recover money, and if monies are due, then what's the course of action you can take.
Right. Okay. Now, what are some of the considerations when it comes to entering into these contracts?
Prashant, now when you enter into a contract with a person, parties, the law assumes that parties are free. Parties have the capacity to contract, both parties. So then both parties will be negotiating terms. And you will be putting these terms, and then I'll say whether I'm agreeing or not, and thereafter you will formally write it down and then say you're agreeing, you're giving me this much of money in Colombo, or where the place in which you're signing the agreement. Now you'll be entering that in the text as well. And then thereafter both parties will be placing their signatures. Now, in a normal scenario, both parties placing their signatures would be enough. But certain people would like to get involved, where they would like to have the services of witnesses as well. And thereafter, once the agreement is entered into, then it is binding on both parties. You also have to hold on to your end of the bargain, and I would also like to follow up with my end of the bargain as well. And thereafter, the money which is stipulated in the amount should be handed over or transferred, and then thereafter or let's say the person from, let's say the agreement is between A and B, then both these parties, let's say B is the one who's taking money from A, and then B also would have to start off with this repayment program as stipulated in the terms.
Right. Now, you mentioned that some people just sign, just the two parties sign, whereas some prefer having witnesses. Do you feel like there is a sense of higher security and more protection of the contract when you include witnesses?
Prashant, now in a contract, both parties placing their signature would be sufficient. But however, like I mentioned previously, now when if there is no issue at all, if both parties hold on to their end of the bargain, then there won't be any issues. But however, like everything in life, there will always be instances where there will be problems. So then when you have to take this issue before another forum, the need would arise for the evidence to be led, and then having witnesses would allow both parties, actually, let's say A and B. Now if A has a problem with B, then A would have the opportunity to bring two witnesses who were there while the matter was being signed. So then B would not be having the opportunity to say that, you know, he was under duress, and then he didn't know what the terms were, and these terms were not negotiated between the parties. So those kind of little issues would be ironed out when witnesses are there.
Right.
But on a general scenario, if two parties agree and two parties sign the document, that itself would be sufficient.
Right. Okay. Now, hopefully, the witnesses have to be unbiased and not supportive of one party. Now, let's speak a bit about the importance of written contracts.
So, Prashant, now written contracts would allow both parties, like I mentioned earlier, to continue with their claims. Now, let's say I obtain money from you, and then if we don't put that into writing, on a later date, you might come up to me and say, you know, you borrowed 50,000 from me, whereas I only borrowed like 10,000. And you might also say, you know, I gave the money to you on the basis that you promised to pay 20% per annum, whereas at the moment you just handed me the money and said, you know, just pay me on a later day. So to grease out and to iron out all these small minor details and conditions, actually, let's say, which are there. Let's say I take money from you, and then I say, Prashant, I'm going to pay you back in 3 months. If I don't pay you back in 3 months, you know, as a guarantee, I'm going to do this. But however, if you don't put that into writing, it will just be mere words spoken out that would not amount to anything. That's why we always say, or always ensure, it's always better to be ensure that all the terms are written down, so that no party would have the chance to go back on their word and say, you know, I didn't say this.
Right. So obviously it's very important to have a written contract whenever you're borrowing money, even if it's on a personal level, because sometimes we don't think that because it's a friend or someone who's very close, but it's always good to have a written contract, like you mentioned. Now, what are some of the steps that should be taken when the money is due?
Well, Prashant, now first thing is people would always, you know, like to hold up their end of the bargain, but however, people might fall into unfortunate circumstances where people or the individuals who borrow money would not be able to pay up or hold up to their end of the bargain. Now, in a scenario like that, where first thing you can do is you can just write a letter or mention the fact that, you know, money is owed. Then thereafter, if the process is taking time, and if the other party is not responding to you, which will usually be the case, like after you handing over their money, then thereafter people would try to evade you and, you know, take time in repaying you back. Then, Prashant, the most easiest option would be to go for mediation, because that's an out of court settlement process. Now, according to the Sri Lankan law, any party could go before the mediation board, and it's a very simple process where lawyers are not involved. It's just between the two parties and the mediation, the chairman and the two members.
Right.
So it's a simple process where you go and establish your claim, and then the other party would also have an opportunity to come there and then state their grievance or state their claim or state their defense. And in a later amendment to the Act, now the claims which are taken before the mediation board is raised up to 500,000 rupees. So you can take claims up to 500,000 rupees to the mediation board.
Okay.
Now there's another way in which mediation boards are referred to. That's by way of you going and lodging a complaint before the police station. And then if the money value or monetary value is less than 500,000, the police will transfer or refer the matter to the nearest mediation board. And the other process is, now let's say if the, and continuing with mediation, when parties arrive at a settlement, the mediation board will sign a certificate and then say matter is settled now. If parties don't settle the matter before the mediation board, then there will be a certificate issued for non-settlement, and then you have to take that certificate and annex it to the prospective plaint that you are filing before the courts. Now the other method of initiating action is by way of sending a letter of demand. Now that is being done through your lawyer. You go before your lawyer and say, we are entered into this agreement, and then these were the terms, and the other party was supposed to pay back on these days, and now he is defaulting, and please enter these, because the lawyer would be sending the letter on behalf of you, your instructions. And thereafter the letter of demand would stipulate a time period. Let's say, for example, maybe 7 days or maybe 14 days, and then after the lapse of 14 days, then of course you can start proceedings before the respective courts by way of procedure which is laid down in the Civil Procedure Code of Sri Lanka.
The lawyer of the respective party who is in need of the money or the settlement, when they send out a letter of demand, is there something that the other party's lawyers can do to maybe ask for a grace period or maybe like a counter for the letter of demand?
Yes, Prashant. Now once the other party receives the letter of demand, now let's say like on the previous example we took A and B as our examples. Now A sends a letter through his attorney at law to B. Now let's say the letter stipulates a 7-day time period.
Right.
Now the general law which is out there states that if a letter of demand is received by the other party and the other party is not responding to it after receiving the letter, then the claim in the letter of demand is admitted.
Okay.
That's a general rule. There are exceptions, but as a general rule, that's a very basic method. Now coming back to your question, Prashant, once the other party receives the letter of demand, they can go back to their lawyers or their respective lawyers, or they can seek legal remedies by going to a lawyer and then say, we want to negotiate a settlement, or let's say we want to defend this action and these claims are very vague. Then of course the other party's lawyer would either, like you said, seek for further time and or in otherwise defend by saying all these claims are denied or being denied by my client, or he would also try to counterclaim by saying no, this is not what actually happened, the money is actually owed from you.
Okay. Because
you are the one who violated the terms. And so it would all depend on how both parties would want to instruct their lawyers on these matters.
Right.
But on a personal scale, on a scale, one party receiving the letter of demand would mean that he has to reply. Otherwise, the claim in the letter of demand is established as is deemed as established.
Okay. So when we speak in a general sense, these are things that can actually happen in real life. What if A sends the letter to B, and due to some unavoidable accident or circumstance, B does not receive the letter? There is some issue in between. What happens then?
Well, Prashant, now let's say sending a letter of let's say of this scale, you won't be using the normal post in a practical scenario.
Right.
Either you would courier it, or either you would make sure that you send it via registered post, or let's say the other methods would be now there are instances where you just email it. Let's say the other party is abroad, you email it and then you courier it as well. Now, like you mentioned, Prashant, there are instances where the letter is lost, or let's say the other party did not actually receive it. So in a scenario like that, like how we mentioned, the general principle is that it is deemed as sent and it's deemed that the other party received it. But however, if the other party is able to come, let's say when action is instituted, the other party is able to come before courts and say, we never received such a letter. Then of course the person sending the letter has to establish that no, in an actual sense we sent the letter. But if you are sending it by way of courier or registered post, then there is always the receipt that you'll be getting, saying that the letter was delivered to this person or this address, and then this person or his representative accepted the letter, and the person accepting the letter has to sign and then accept the letter.
Okay, so basically you have to have evidence, and you can't just say that you didn't receive the letter.
Yes.
And once it's sent, the steps have already begun. Okay. Now, what are some of the out-of-court measures that can be implemented when recovering the money?
Like I mentioned, Prashant, first of all, mediation is there.
Yeah.
So you go before the mediation board and state your claim when the issue is less than 500,000 rupees, which is worth less than 500,000 rupees. If not, the other method was like we mentioned, sending a letter through your attorney and then them replying, saying, we need further time, or we'll negotiate a process where both parties can agree. Or let's say in the agreement itself, it says that they have appointed someone, and then they go before that person and then they state their claims and try to mediate something, because in the agreement itself says if there is some dispute, we'll go before this person, because parties are free to enter into terms, Prashant.
Right.
And the terms that they enter in the agreement are voluntary. That's at least that's what we deem. That's what the general presumption is. Now, in a normal scenario, one party would be having the upper hand, and he'll be the one who will be negotiating all the terms, and he'll be the one who will be putting down all the terms. But it is accepted that both parties have negotiated terms, and they are the ones who have drafted this as a team.
So basically, if all is handled after the letter of demand is sent, it's basically finished from there. But if that doesn't happen, and if like we mentioned, hypothetically the party does not respond, or they do not oblige to what is required by the letter of demand, and it does go to court, how does that process work?
Prashant, the court process is actually twofold. Now let's say you have in the civil procedure code, there are two sorts of action you can take. One is the normal procedure, which is laid down, and there is always the other one is the summary procedure as well. Now, for the ones that we were discussing on, let's say the normal contracts that we have laid, the parties have laid down, that's the normal procedure which is laid down in the civil procedure code. Whereas section 9 states that either it could be filed in the respective court where the defendant resides, or it could be filed if it's relating to some land, it's filed in the jurisdiction where the land is situated at, or if it's regarding contract. Now, in a contract, you will be stating the fact that this contract was entered into. For example, let's say if you and I are entering into a contract today itself, we'll be saying, we are entering into a contract in Colombo. And or wherever the cause of action arose. So that needs that requisite is there, and then thereafter you have to the civil procedure code also lays down in other sections, let's say 39, 40, and all these 40 from there onwards, the Civil Procedure Code lays down the procedure as to what sort of relief you can seek. Now, if it's relating to a contract, now you should also seek whether it's a normal breach or a material breach which goes into the root of the contract.
Okay.
Now, and the relief as well. And thereafter, after filing the case, the summons would be served on the other party, and the other party has to come before court. And then thereafter, the other party, like we discussed earlier, they might come on the first day and say they file proxy on behalf of their lawyer files proxy on behalf of their client, and he might come before court and say we are ready to settle the matter. But usually you go to court as a last resort. So they would be coming up with their defense as well, and then thereafter the other party would be filing their defense in the sense of an answer.
Okay.
And then the matter would be going into trial. And in the trial, since it's regarding the contract that we discussed, both parties, like the plaintiff who is filing the matter, has to establish the fact that we signed this agreement and both parties had full discretion in filing the matter and they were fully aware of the terms, and both parties signed the other party signed willingly, and these terms which are laid down were breached by the other party, and now he owes me this much of money.
Okay.
And you might also say we are seeking legal relief in the sense damages as well, and then legal costs, and you have to establish the fact that these things were breached, and you have to bring down evidence. And the other party might also come up with their defense as well, or the general denials that they are relying upon. And then thereafter, once the matter goes into the trial, the learned judge would be looking at both parties, the claims which are brought down by both parties and the defenses which are raised, and then thereafter, on a balance of convenience, the judge would be looking into the matter, and then he would weigh on as to the evidence laid before him, and then granting a judgment on the matter itself.
Okay.
And then it will be concluded. But of course, the other party has the right to appeal as well.
Now, these out-of-court steps that we spoke about, like mediation and all of that, you mentioned specifically that those steps can be taken if the sum of money is less than 500,000. If it's more, how does it work? Does it go straight into a court process, or?
If it's more than 500,000, Prashant, now accordingly, as per the time being, you have to go to court. But if it's less than 500,000, you can't go into court straight away.
Okay.
You have to go before the mediation board first, and then if parties settle, then there would be no issue. But if parties don't settle, then of course you have to get that certificate of non-settlement.
Right. So it's not an option. You have to go before the mediation board before going to courts.
You have to go to mediation.
Right.
Of course, there are exceptions, certain exceptions which are laid down, but in a general sense, if the matter concerning the agreement is the monetary claim is less than 500,000, it's a must that you have to go before the mediation board.
And if it's more, you don't, and instead
there's no requirement.
Right. Instead, you can straight away proceed to court.
Straight away proceed to court.
Okay. Right. Thank you so much. That was Krishan Fernandopulle, attorney at law, and we discussed a lot about lending and borrowing money on a personal note. Thank you so much for being with us this evening.
Thank you, Prashant. Thank you for having me.
All right, and that winds up today's episode of Law and Order. Do join us next week as well. Till then, have a great day.